When I first began to study the idea of Ellen White copying from other authors, I thought there must be some explanation for all of this. So one of the first places I went was to the White Estate's website to see what they had to say. At the White Estate and elsewhere, I found the prime defense of the church was that a copyright attorney had cleared her of the plagiarism charges made by Ray, Canwright, and others. I was taken aback by this because on one hand I had seen the plagiarism with my own eyes from the original books open before me, but on the other hand all of the leaders in Adventism were saying that she did not plagiarize. But these are mutually exclusive positions. They cannot both be right. So I wondered how to determine which of these views was correct. After researching and speaking to others, I found many Adventists will simply read the headline that Ellen White was cleared of plagiarism by this attorney and will immediately throw the conclusion in your face and walk away. The summary or conclusion for this report provides the evidence they are searching for with the least amount of effort invested. In effect, they are saying, if an attorney has cleared her, what more is there to say? But there is so much more to say, and it would be unwise to disregard the mounting evidence from others simply because of a single man's opinion. It's also important to recognize that there is an obvious conflict of interest in the White Estate publishing something against Ellen White. Let me put it a different way. If you're an Adventist and your Mormon friend comes up to you with questions about Joseph Smith, would you recommend they go ask the Mormon Church for validation of his prophetic gift? Or would you recommend they read widely to see different information? What if the Mormon Church hired an attorney to argue that Joseph Smith did not plagiarize? Much is the same as you begin to study Ellen White. If you only read the Church's opinion, you will always arrive at the same conclusion. You cannot expect to go to the organization that promotes the prophet for unbiased answers to questions that oppose the prophet. It's circular reasoning. Thus, unless you broaden your studies, you cannot evaluate if you have all of the information to make an informed decision. And I believe when you have someone making such extraordinary claims as being the last day prophet to the world, a little more time is warranted to study the origin of her writings. So although this and other videos will be quite long, I pray that it'll be helpful to you on your walk with Christ and to help unravel this debate between whether or not she was a plagiarist. The main topic of this video and the next will be the legal opinion of the attorney Vincent Ramik, who was hired by the chief attorney of the General Conference, Warren Johns, to defend their prophet Ellen White. This came about after the early 1980s, when the Washington Post, Los Angeles Times, Newsweek, and Time magazine published that Ellen White had copied large amounts of material from other writers. As I mentioned before, when I began to test Ellen White, the Ramik Report was one of the first documents I came across in her defense. So I felt this document was the perfect place to begin my cross-examination. But before we go back to the 1980s and look at this attorney's report, we need to go back to the 1800s first, because we first need to ask what was plagiarism defined as in the 1800s. We must define our terms first. Certainly in our current time and culture, we all agree with the definition of plagiarism as defined here in 2021 from a few modern dictionaries. Plagiarism, the process or practice of using another person's ideas or work and pretending that it is your own. The practice of taking someone else's work or ideas and passing them off as one's own. To steal and pass off the ideas or words of another as one's own. To use another's production without crediting the source. But the Adventist authorities often say it was different back then, or some variation of that argument. So in order to discuss the subject of plagiarism in the 1800s and the attorney's report, we must begin by reading the definition from the 1800s. Interesting enough, I came across a quote written in 1880 in the Review and Herald from James White, husband of Ellen White. He wrote, "We look back with a good degree of pleasure to the month of July 1849 when we published the first number of the little paper called Present Truth. We sat down to prepare the matter for that little sheet and wrote every word of it, our entire library comprising a 3-shilling pocket Bible, Cruden's Condensed Concordance, and Walker's Old Dictionary, minus one of its covers. Here James White is listing the very dictionary he and Ellen White had in their possession, all the way back to July 1849. So I obtained a copy of this dictionary. But before I open this up, let's ponder for a second about what a dictionary is. The sole purpose of a dictionary is to define words, It allows us to know the meaning of the words during the time that the book was published. Here is Walker's dictionary. This edition was printed in 1825, and on page 399 we find plagiarism, theft, literary adoption of the thoughts or works of another. So in 1825, if you adopted someone else's thoughts or writings, you met the definition of plagiarism. But let's keep going and see if this was a consistent thought in other dictionaries as well. Here is Webster's dictionary from 1852. And on page 831, we find plagiarism, the act of purloining another man's literary works or introducing passages from another man's writings and putting them off as one's own, literary theft. So passages taken from another man's writings, as we saw Ellen White do in the last video, was seen as theft in 1852. But I want to break this definition down even further. Let's look at what purloining meant on page 891. Purloin, literally to take or carry away for oneself, hence to steal, to take by theft, to take by plagiarism, to steal from books or manuscripts. So while the definition stands by itself, if we insert the definition of purloin, we have plagiarism is the act of stealing from books or manuscripts or introducing passages from another man's writings and putting them off as one's own. This is plagiarism defined in 1852. This is before any of Ellen White's books were written, except for a sketch of the Christian experience and views, which was published 1 year before this edition of Webster's Dictionary. Let's look at a handy dictionary of the English language by John Wood, published in 1880. On page 207, we find plagiarize, to steal from the writings of another. Plagiarism, literary theft. Plagiarist, one who purloins, which means steals, the writings of another. These definitions are again consistent with what we have seen from the first two examples, and with modern definitions. Written here in 1880, 3 years before Sketches from the Life of Paul was published. Let's look at one more from the 1800s. Here is the Standard Dictionary of the English Language by Funk and Wagnalls, Volume 2, published in 1895. For reference, Desire of Ages was published in 1898, 3 years after this dictionary was published. We read, plagiarism, the act of plagiarizing or appropriating the ideas, writings, or inventions of another without due acknowledgement. Specifically, the stealing of passages, either word for word or in substance, from the writings of another and publishing them as one's own. Literary or artistic theft, a writing, utterance, or invention stolen from another. Note that it says stealing of passages. It doesn't say you have to steal the whole book, as we will see Ramik argue shortly. And why is this wrong? It is because there is no due acknowledgement. The acknowledgement is what demonstrates whose mind it originated in. The controversy surrounding Ellen White's books are that we are now finding that her writings originated in other people's minds, while she led us to believe it originated either in her mind or from heaven. In fact, the trustees of the early Adventist printing press went on the defensive early in Ellen White's career, when she published An Appeal to Mothers in 1864, a book the Adventist Church would like to forget. In this book, her health advice was so similar to that of other authors on health reform before her, the trustees felt it prudent to add to her book, "We have thought proper to add to the foregoing the following testimonies from men of high standing and authority in the medical world, corroborating the views presented in the preceding pages. And in justice to the writer of those pages," which was Ellen White, "we would say that she has read nothing from the authors here quoted and has read no other works on this subject previous to putting into our hands what she has written. She is not, therefore, a copyist, although she has stated important truths to which men who are entitled to our highest confidence have borne testimony." So what are they saying here? They are saying she did not copy her views from others and pass them off as her own or from God. This admission gives an insight into the thoughts of their day that copying without acknowledgement was wrong, and they felt they needed to add that she was not a copyist because her writings simply mirrored health reformers' books that preceded hers. If there was nothing wrong with copying, they would not have mentioned this, but the fact that they added this in print to her book demonstrates that they did not want the spirit of prophecy to appear to have thoughts and ideas that originated from others. Why? Because it causes a loss of reputation. The trustees from 1864 all the way to the present day have been trying to defend the same thing, her reputation based on her alleged source of information. But you may be asking yourself, maybe this was a unique example, and maybe these dictionary definitions were not held by those in the 1800s. What if these definitions simply gathered dust in the dictionaries of many homes, and no one cared about plagiarism as the Adventist Church promotes today? But this wasn't the case. The very same year that Appeal to Mothers was published, Uriah Smith, an author, pastor, educator, and leader within the Adventist Church, published this article in the Advent Review and Herald on September 6, 1864. At the time of this publication, he was the editor of this periodical, with James White, who was the husband of Ellen White, as the president of the publication. He begins by defining plagiarism the same way as we have read from the dictionary. He wrote, "Plagiarism. This is a word that is used to signify literary theft, or the taking of productions of another and passing them off as one's own. In the World's Crisis of August 23, 1864, we find a piece of poetry duly headed, 'For the World's Crisis,' and signed Luthera B. Weaver. What was our surprise, therefore, to find this piece, our familiar hymn, 'Long upon the mountains weary have the scattered flock been torn.' This piece was written by Annie R. Smith and was first published in the Review, Volume 2, Number 8, December 9, 1851, and has been in our hymn book ever since the first edition thereafter issued. But worst of all, the piece is mutilated, the second and most significant verse being suppressed, namely, 'Now the light of truth they're seeking, in its onward track pursue, all the 10 Commandments keeping, they are holy, just, and true. On the words of life they're feeding, precious to their taste so sweet, all their master's precepts heeding, bowing humbly at his feet.' But perhaps this would too clearly have revealed its origin, as scarcely any class of people at the present day, except Seventh-day Adventists, have anything to say about all the commandments of God. Now pay attention to what he says next. 'We are perfectly willing that pieces from the Review or any of our books should be published to any extent, and all we ask is that the simple justice be done us, by due credit being given.' So he begins this column by defining plagiarism as literary theft or taking the productions of another and passing them off as one's own. This is the very thing Ellen White has done, and his definition here is the same definition we have read in the dictionaries. So we can see what plagiarism was defined as and known as by the Adventist leaders during the 1800s. In this example, Smith is angry that an injustice was done. It's important to note that the poetry that was used was also not used in its entirety, but a significant portion was left out. It was even mutilated. Smith goes on to complain that part of the poem was erased to conceal the origin. Note how they close the article by saying, "We are willing that pieces of the Review, this periodical, and books may be used. We simply ask that the simple justice be done us, by due credit being given." And what books are they referring to? Well, they are pushing to sell Ellen White's books in the next column. Do you think they would have published this article if plagiarism was common back in those days and of no issue, as the Adventist apologists will say? Here, all the way back to 1864, it is written that the right action, the just action, was to give credit. This is similar to what the trustees were saying the same year, in that, in justice to Ellen White, she did not simply copy her views from others. Note that there is no mention of legal ramification in either of these statements. Plagiarism is spoken about as a moral, ethical issue here. And it's important to point out that you can have plagiarism without legal ramifications. In fact, there were several top editors and leaders in the Adventist Church in the 1800s who called out plagiarism in print, some of which wrote much more damning articles than what I have shown so far. But I'm going to save those for now and show them instead in part 5, where I'll go into more depth than I have time for in this video, because I really want to get to the chief defense of the Seventh-day Adventist Church, the attorney Vincent Ramik's legal report. So after I had filmed the first part of this video, I noticed I had overlooked something. As I was compiling my references, I discovered that the Ramik Report was copyrighted. I thought maybe I had made a mistake, so I emailed the copyright attorney at the General Conference to confirm that this was the case. She confirmed that the Ramik Report was indeed under copyright, and that I would need the permission of the White estate to show it. So the hailed defense regarding Ellen White's plagiarism cannot be shown without the permission from the White estate, which seems somewhat ironic. So instead of spending 2 hours going through every sentence of the Ramik Report, as I'd already planned, I will instead be discussing the same issues, but with using other sources. I believe this summary will be just as useful as going through the entire document, as much of Ramik's report is repetitive. Of course, you will find a link below the video, and I would encourage you to print the attorney's report and read through it yourself. Let's begin by providing a history of copyright laws. According to the Encyclopedia Britannica, literary editor Richarda Rogersa Bowkera was instrumental in organizing the American Library Association in 1876 and in founding the Library Journal, which he edited for more than 50 years and was a champion of authors' rights. He became a noted authority on copyright law and wrote 2 books on copyright history, literature, and law. In his comprehensive book, Copyright, Its History and Its Law, published 3 years before Ellen White's death, he wrote on the history of copyright in the United States. Intellectual property rights began in the 1780s and 90s to secure for limited times to authors and inventors the exclusive right to their respective writings and discoveries in the United States. These rights followed the English Act of 1710. Later, copyright was granted for 28 years from the time of registration, and in the 1870s, further changes developed. Next, in 1891, the privileges of United States copyright law could be applied to foreign authors. This solved the problem that before this time you could not be legally convicted of copyright infringement or piracy by taking a book from another country and replacing the name with your own. It's important to note here that many of the books Ellen White copied from were from foreign authors, which, whether intentionally or unintentionally, helped to diminish any legal entanglements. However, most of her large books were written or republished after 1892. But to Ramik, this is a moot point, because he argues even if all the books she copied from were under copyright in the United States at the time she wrote her books, he still would not charge her with copyright infringement because she did not affect the sales of those other books. But for most members in the Adventist Church, the issue has never been about copyright infringement or affecting the sales of other authors. The issue is that a prophet's reputation is defined by the source of their information, and she claimed the source of her information was from God, when instead a large amount of her books were from human origin. Further, she denied copying from other authors when asked, and told Adventists to sell her books because God told her so. Now, the Ramik Report is basically split up into 4 main sections: piracy and copyright infringement, which will be the focus of this video, and plagiarism, which will be the focus of the next video. So let's begin by discussing piracy and copyright infringement during the 19th century, as this is what the majority of the Ramik Report is based on. In the 1800s or 19th century, literary piracy meant for the most part to take a book in its entirety or almost in its entirety and resell it without approval from the author. The Encyclopedia Britannica described 19th century literary piracy in this way. Although American literature put down strong roots during the 19th century, piracy from Britain rose to great heights. There was sharp competition to be the first to secure proofs of any important new book. Publishers waiting at the dockside for new British books could produce an American edition within hours, as they did in 1823 with Sir Walter Scott's Peril of the Peak. In the absence of international copyright agreements, the British author usually received nothing. So during this time period, people would snatch a foreign book off an inbound ship and reprint it in the States because there were no international copyright laws preventing this form of piracy in the United States until 1891. However, in contrast, piracy of an American book could have a lawsuit filed against it before 1891 because it was a domestic book. In his book, Copyright, Its History and Its Law, Bowkera wrote on piracy, "The word piracy, since that gentle craft had disappeared from the high seas, has come commonly into use to mean freeboating with reference to literary property. In this sense it is used as early as 1771 by Lacombe in his History of Printing, in which he says, 'They would suffer by this act of piracy, since it was likely to prove a very bad edition.' It was especially applied in America, more or less jocularly, in the days when there was no legal protection for works by English authors, to the reprinting chiefly of English novels without authority from or payment to their authors, when publishers whose imprints were chiefly on such reprints were commonly known as pirates." This secondary meaning has been accepted by the dictionary makers and the use of English law authorities, and now in the New American Code, of the phrases pirated works and piratical copies gives the word specific legal status. Notice here piracy is a word with legal status. Let me show you the definition of piracy from the Webster's Dictionary from 1852 that we looked at earlier. Piracy, an infringement of the law of copyright, or the publishing of the writings of another without permission. And let's look at Funk and Wagnalls from 1895 that we also looked at earlier. Piracy, the appropriation or unauthorized publication of another's literary property, as a book, engraving, or other copyrighted work, especially when the laws provided no redress. Literary piracy. A literary pirate, therefore, was a person as a publisher who appropriates or publishes without permission and without offering compensation the literary or artistic work of another, said especially in the United States of such publishers before the passage by Congress of an international copyright law in 1891. So what's the difference between these definitions of piracy and that of plagiarism that we saw earlier in this video? The difference is that plagiarism is taking another's ideas and words and passing them off as your own, even without committing piracy or copyright infringement. If the copying was not extensive enough from a single author for a lawyer to get involved, you would not be committing piracy or copyright infringement. The definitions of piracy in the dictionary make the distinction that the offense involved infringement of copyright. I will be discussing plagiarism more in the next video, but for now let's continue with Bowkera's definition of piracy. Piracy is the comprehensive term now in common and legal use to mean the stealing of another author's work by reprinting it in full or in substantial part without the authority of the copyright proprietor, and is in fact an infringement at wholesale or otherwise of the author's exclusive right. This is of course prohibited by the law to the full extent of its jurisdiction, and is punishable as prescribed in the law. The true test of piracy, said Judge Shipman in the U.S. Circuit Court in 1875 in Banks v. McDivitt, which I will add was a case between two American authors, is whether the defendant has in fact used the plan, arrangements, and illustrations as the model of his own book, with colorable alterations and variations, or whether the book is the result of his own labor, skill, and use of common materials and common sources. Judge Story, which was also quoted by Ramik as the most influential judge of copyright law in the 19th century, said in 1841 in Folsom v. March about piracy, "If so much is taken that the value of the original is sensibly diminished, or the labors of the original author are substantially to an injurious extent appropriated by another, that is sufficient in point of law to constitute a piracy pro tanto," which means to that extent. The entirety of the copyright is the property of the author, and it is no defense that another person has appropriated a part and not the whole of any property. So going back to Bowkera's quote, we see he is writing here that the whole book does not have to be copied to constitute piracy. It can simply be the most substantial part, or whatever part affects the profits of the original author's book. This was the important issue in piracy law at this time. This is what could have brought a lawsuit summons. This is what the judicial cases were looking for. There must be an injury to another author for a court case to proceed. Otherwise, there would be no reason for all of the legal fees and time spent to sue someone for taking your ideas and passing them off as your own. I'm going to be very repetitive in this video because it is crucial to understand these definitions in order to understand what Ramik is arguing for by law and what he is not arguing for by law. For literary piracy to occur, there must be a book printed either in full or with a substantial amount to injure the profit of another author for a court case to proceed. You may be wondering, but what is copyright infringement? Well, copyright infringement is the box in which piracy sits. Again, the central question lawyers looked for in terms of copyright infringement and piracy was, does the copied material diminish the labors of a single author? Let's continue with Bowkera. Infringement is commonly taken to mean specific invasion of the author's rights rather than wholesale piracy. And the question of what is infringement or literary larceny is more often a question of the interpretation of the facts than the construction of the statute. The legal cases arising under infringement constitute a very large proportion of copyright litigation, demanding as they do judicial determination as to the acts complained of in each particular case. It is therefore impossible in this volume to give citations or references for the hundreds of cases recorded in the law reports or in the various works on copyright. But it may be noted that the footnote citations in McGillivray's Law of Copyright cover a very large number of American as well as English cases. No treatise on copyright can apply, however, in advance the general principles of copyright to the infinite variety of possible cases, and only generalizations and a few illustrative cases can here be given. Copyright infringement is a question of fact rather than of intent. I want you to remember this word intent, as this will be important later when we discuss plagiarism. It is not a valid defense that the infringer is ignorant, nor, on the other hand, can anyone be held for intention to infringe when the act of infringement has not been accomplished. What Bowkera is saying here is that even if someone copied from a copyrighted book without knowing he shouldn't do so, the fact is he is still infringing the copyright work of another, and this is what the law looks for. It does not matter that he did not know what he was doing. This is different from what Ramik will point out, and that is that plagiarists intend to pass words and ideas off as their own. The intent is what makes plagiarism plagiarism. Let's continue. The New American Questions Code nevertheless recognizes knowledge and intent in certain cases of punishment or damages by the use of the words willfully and knowingly. The letter of the law is in general that the infringer must be held responsible and must make good any damages suffered by the copyright proprietor, but proof that he had no guilty knowledge or intent may affect mitigation of punitive damages. So what are the principles of infringement? Copying is not confined to literal repetition, said Judge Clifford in Lawrence v. Dana in the U.S. Circuit Court in 1869, but includes also the various modes in which the matter of any publication may be adopted, imitated, or transferred, with more or less colorable alterations to disguise the source from which the material was derived. Nor is it necessary that the whole or even the larger portions of the work should be taken in order to constitute an infringement of copyright. So the question of copyright became, did you take from another writer and make small colorable alterations so that it was hardly any different from the original? Or was the book or passage derived from common sources of knowledge, and the similarities were simply accidental? Now, while Ramik also brings up this same case by Lawrence v. Dana, he adds from the case that what is weighed is the effect on the sale or profits of the original author, similar to what we read for piracy. Let me illustrate these concepts visually. Plagiarism was the stealing of passages either word for word or in substance from the writings of another and publishing them as one's own. So as an author copied from other books, at some point the court saw that they met the criteria of copyright infringement by injuring the profits of another or copying a substantial part of their book. That is when the law stepped in, because the law can demand money for damages to the profits of the original author. If there was no injury to the profits of another or copyright infringement, there was no lawsuit. If there was no precedent for a lawsuit, then there was no legal crime. This is why Ramik concluded that even if the Great Controversy was made up of 88 different authors, it was not a single author that had their financial profit affected, and thus she is cleared from his standpoint from any copyright infringement or piracy. But it's important to point out that nowhere in his report on the Adventist prophet does he ever even hint that Ellen White claimed to be more than another author. But we must remember he is an attorney, and claims of special revelation is not his specialty. Not to mention it would undermine his client and point out the absurdity of arguing she did not copy a single author, thus there is no issue here. The real question that should have been asked is why would it take a prophet or messenger from God 88 different authors to write a book? How does that work to strengthen her burden of proof that she had received new light from heaven? What proof of divine guidance was there? If you see the blueprint, it is more unreasonable to infer the supernatural as an explanation for the writing of her books. Now, since we are talking about the Great Controversy and infringement, I thought about how Bowkera and Ramik pointed out that the true test of piracy was whether the defendant had in fact used the plan, arrangements, and illustrations as the model of his own book. This statement reminded me of what E.S. Ballinger and Walter Ray pointed out regarding the plan, arrangement, and illustrations used by Ellen White in the 1887 edition of The Great Controversy. While I'm not going to attempt to prove infringement here, as this could only be done in a 19th century courtroom, this segue does bring up an important defense by the church, which I will talk about in a few minutes. It also lets us see how Ellen White put together her books. Here in the 1887 edition preface of The Great Controversy, we read, "Apart from the Bible, this book presents the most wonderful and intensely interesting history of this dispensation, to the complete restoration of all things, that has ever been published. We have faith that the merciful Father in his kindness bestowing upon his waiting people the light and instruction which they specially need in the perils of the last days. God is willing to give his Spirit to those who ask him, to those who call upon him in truth. We believe that the writer, Ellen White, has received the illumination of the Holy Spirit in preparing these pages, in laying before us the nature of the great controversy between Christ and Satan, that we may be warned against the snares of the enemy, and prepared for an inheritance with the saints in light. We believe that no one who knows what it is to hold communion with our Heavenly Father will fail to realize that the writer of these pages, Ellen White, has drawn from the heavenly fountain and has received help from the sanctuary." On the left side, we have the 1887 edition of The Great Controversy, and on the right side, we have a late 1870s edition of The History of Protestantism by J.A. Wiley. Here is an example of where she used the plan and illustrations of a foreign book in crafting her own. The White estate and other websites in her defense have said that her son, Willie White, purchased full rights to these illustrations and thus removed the necessity of due credit from the artist. However, this only further reinforces the idea that Ellen White did not want to give credit to others. But it doesn't make sense to me why they would go through the trouble of purchasing the illustrations, because Ramik would argue the illustrations would not be under copyright as they were from Europe, and the 1891 International Copyright Agreement would not have been enacted at this time. Thus, there would be no legal issue here. However, the White estate claims the proof of this agreement was burned up in a 1906 fire. While being very convenient, even if this was what happened, they ignore the second part of Ray's point, which was that it was not only the illustrations that were used as a model for this section of the Great Controversy, but the text as well was copied from Wiley. This is with no credit given, and as we have read in the preface, it is claimed that the Holy Spirit helped her prepare these pages as she drew from the heavenly fountain. But you see, in the same year that this book was published, there was a thorn growing in the foot of Ellen White. The beloved pastor, leader, and close friend of James and Ellen White, D.M. Canwright, departed the Adventist Church in 1887, when he realized the central doctrines of the Adventist Church were not biblically sound, and that his friend Ellen was not who she claimed to be. In fact, at the time of his departure, and even today, his reputation has been tarnished in an attempt to diminish his theological differences and views of his friend Ellen White. However, we can see at the time of his departure that the main publication of the Adventist Church, the Advent Review and Herald, and editor G.I. Butler, defended Canwright in 1887 when he wrote, "What moves us now to speak concerning Elder Canwright is the fact that we learn from sources. We cannot question that some persons among us write to him or speak of him in a way that is calculated to create an acrimonious spirit, or bitter spirit, imputing unworthy motives and saying things of a personal nature which better by far be left unsaid. We see no good that can possibly arise from this course, but only evil. Elder Canwright has to answer to God alone for his motives, and the Lord has never placed us on the judgment seat to delineate or expatiate upon them. In leaving us, he has taken a much more manly and commendable course than most of those who have withdrawn from us, coming voluntarily to our leading brethren and frankly stating the condition of mind he was in. He did this before his own church in our presence, and, so far as we know, has taken no unfair, underhanded means to injure us in any way. He goes from our midst with no immoral stain upon his character, and chooses associations more pleasant to himself. This is every man's personal privilege, if he chooses to take it. So now going back to that rare 1887 edition of The Great Controversy, we must ask ourselves, why would an author and printing company go through all the trouble of publishing a book, including the meticulous process of crossing T's and dotting I's that all books go through before printing, only to come out with another version of their book the following year? Now with brief credit to other authors being given for the first time in Ellen White's career. The official line is that the book plates wore out, and so they needed to be remade. But I have a different theory. We have to consider the atmosphere surrounding the scramble for the new edition. Canwright published a book entitled Seventh-day Adventism Renounced in late 1887 or early 1888, and wrote about Ellen White on page 44. She often copies, without credit or signs of quotation, whole sentences, paragraphs, and even pages, word for word from other authors. Compare Great Controversy, page 96, with History of the Reformation. Indeed, her last book, Great Controversy, which they laud so highly as her greatest work, which we just saw a few minutes ago, is merely a compilation from Andrew's History of the Sabbath, History of the Waldenses by Wiley, Life of Miller by White, Thoughts on Revelation by Smith, and other books. I have compared many pages from all these and find that she has taken from these word for word and page after page. She gives no credit to these authors but claims it all as a revelation from God. She is a literary thief. Webster says, plagiary, a thief in literature, one who purloins another's writings and offers them to the public as his own. Exactly what she does. Canwright further began to receive exposure in newspapers around the country for his book and insights into Ellen White's life and writings, such as in this column from the Michigan Christian Advocate in 1887. So in 1887, Ellen White had a problem. Her copying in the Great Controversy was being known by more and more, and I can only imagine she needed to put an end to this issue quickly. So she went through the process of publishing a new edition in 1888. In this edition, and for the first and only time in one of her books that I have seen, she stated, in some cases where a historian has so grouped together events as to afford, in brief, a comprehensive view of the subject, or has summarized details in a convenient manner, his words have been quoted. But except in a few instances, no specific credit has been given, since they are not quoted for the purpose of citing that writer as authority, but because his statement affords a ready and forcible presentation of the subject. Here we have in the 1888 edition of the Great Controversy, Ellen White, in a bind, gives the first and only vague credit to other writers in her books. Then, in further revisions of the Great Controversy, more credits were added than were contained in the 1888 edition. But I found that the White Estate and other defenders bring up this statement of hers over and over again in an attempt to prove she gave credit to other writers in her books and that she was not trying to hide anything. But I read their arguments and I scratch my head because if that were true, she should have included credits in previous publications, such as the 1887 edition of the Great Controversy, the 4-volume Spirit of Prophecy series, Sketches from the Life of Paul, the Testimonies of the Church published by 1888, and others. But these credits never happen, and they have yet to be added even to this day. Let me show you how the same section on the Waldenses, as I showed before from the 1887 edition, was previously published in the 1884 edition of the 4th volume of the Spirit of Prophecy. As you can see here, no credit was given. So even in her book entitled The Spirit of Prophecy, she was using material from Wiley and others without any credit. To say she was not trying to hide anything, as they will say by quoting the 1888 edition, they are implying that it would be wrong if she did not credit. Yet in chapter after chapter of her books, we see that she did hide her sources. However, if she were honest, as they will say she was by this one example, it would logically follow that books before and after 1888 would have credit, such as Steps to Christ, Patriarchs and Prophets, Desire of Ages, Acts of the Apostles, and others. But she did not credit other authors in these books, and they are written as though the material all came from her. As far as I can tell, she only gave credit when the exposure became an issue to her reputation, as someone who was said to have received help from the heavenly sanctuary. But even after the revised 1911 edition of The Great Controversy, published 4 years before her death, and now with credits given to some historians, she still continued to withhold sources. So once again, this idea that she was not trying to hide anything because of her statement in the preface of the 1888 edition is simply false and misleading. Here is another example from Ray, where Ellen takes more ideas from Daniel March's book, Night Scenes in the Bible, published in this edition from 1870, 41 years before this 1911 edition of The Great Controversy. Here on page 631, we read Ellen's thoughts about angels. Celestial beings have taken an active part in the affairs of men. They have appeared clothed in garments that shone as the lightning. They have come as men in the garb of wayfarers. Angels have appeared in human form to men of God. They have rested as if weary under the oaks at noon. They have accepted the hospitalities of human homes. They have acted as guides to benighted travelers. They have with their own hands kindled the fires at the altar. They have opened prison doors and set free the servants of the Lord. Clothed with the panoply of heaven, they came to roll away the stone from the Savior's tomb. In the form of men, angels are often in the assemblies of the righteous. In the council hall and the court of justice, these heavenly messengers have shown an intimate acquaintance with human history. They have proved themselves better able to plead the cause of the oppressed than were their ablest and most eloquent defenders. They have defeated purposes and arrested evils. So it appears to me that even after the accusations of Canwright, she still only gave partial credit in this book. Of course, the accusation by Canwright and the reciprocal providing of some credit shows that due acknowledgement was expected all the way back to 1888. And as we saw, justice by credit was expected even further back to 1864 at the beginning of the video. So why did it take Ellen White so long to acknowledge partial sources, and only in one of her books? It's something to contemplate. We must ask ourselves, what was her intent? And as we have seen in the example from March, she continued to hide literary sources while stating, the Great Controversy should be sold everywhere. Sister White is not the originator of these books. Why? Because they contain the instruction that during her life work God has been giving her. They contain the precious, comforting light that God has graciously given His servant to be given to the world. Now for a quick summary. According to this paid attorney, because legally many of the books she copied from were no longer under copyright or were foreign books where copyright did not apply, she was not guilty of any wrongdoing. Also, because her books were not a near exact replication of another book, she is cleared of copyright infringement. If you read Ramik's full report, he will list several legal cases that discuss that in order to be convicted of copyright infringement in a court of law, you have to nearly copy an entire book from another author and cause them financial loss because of your own publication. There, of course, is no mention of the dictionary definition of plagiarism as passing off another's work as your own, or the morality of stating that you saw a vision that was actually from another author, or that your books were produced with light from heaven without quotation. But Ramik simply provides a legal opinion on the matter. By this logic, if I decided to claim to be a prophet in the late 1800s, I could use Ellen White's writings, including some of her visions, and as long as I did not copy an entire book or affect the financial profit of her books, I could place my name on it, and the White estate could not say I did anything wrong. Of course, this completely misses the whole point of why plagiarism causes a loss of reputation, and you can quickly see the nonsense of the position they hold. Think about the argument here. Would 88 different authors provide more supporting evidence of her prophetic gift, or would it undermine it? But Ramik never speaks about her as a prophet, only as an author. Research and reading broadly is one thing. Signing your name to another's words and ideas as proof of your prophetic gift is another. You cannot say on one hand that one of the proofs of her gift of prophecy was that she was so prolific and had beautiful writings, while on the other hand say she can copy from as many authors as she wants, as long as it wasn't the majority of one book from a single author. Even their common saying of, well, everyone copied back then, again undermines their own argument that one of the signs of her gift was her abundance of writings. You can't have it both ways, but I find they must allow as much copying as necessary to continue to uphold the prophetic gift. I also ask myself, what is the intent of an organization copywriting the chief defense of their prophet's plagiarism, so that a thorough discussion of the report cannot be held openly? So I've discussed piracy and copyright infringement, but I haven't discussed plagiarism in much detail yet, except for the first 15 minutes of this video. The definitions from both the dictionaries and the 1864 column from the Advent Review and Herald are pretty clear. But what does Ramik think? He wrote, "One of the most important factors from a legal standpoint between the legal crime of piracy, copyright infringement, and the act of plagiarism," notice he does not call plagiarism a legal issue as he does piracy and copyright infringement, "is the intention with which such appropriation is made." Now pay attention. A plagiarist, therefore, takes from another and utilizes that which is taken with the intent that the appropriated material is viewed as originating with the appropriator and not the originator. Well, isn't this what Ellen White has done? He continues, "Therefore, Paul was eminently correct in concluding from a literary viewpoint that the plagiarist always hopes that he will not be found out. And though more might be added from a legal viewpoint, the intent of the taker is of paramount importance." So the act of plagiarism is not inherently a legal issue, but a moral, ethical one. And this is what I will discuss in Part 4, The Intent of Ellen G. White.